My name is Barton Morris. I'm the principal attorney at the law office of Barton Morris, and I can be reached at michigancriminalattorney.com. I can be emailed at barton@michigancriminalattorney.com. You can see me on YouTube, on Facebook, on Instagram, and a bunch of other places online. This video is talking about marijuana, being a marijuana user, medical marijuana user, recreational marijuana user, and how it relates to carrying a concealed weapon or just being in possession of a weapon. This is a question that I get very regularly. A lot of people call into this office about this question. I get a lot of questions online. What is the legality of a marijuana user to be in possession of a firearm? It is somewhat of a complicated circumstance. The reason being is because Michigan law does not necessarily equate with federal law. These two different jurisdictions are competing with each other almost, especially when Michigan has legalized adult use of medical marijuana. So let me begin by talking about federal law, because this is exactly what makes things really complicated to understand. First, as many people know, marijuana is a controlled substance, and it is still unlawful under federal law. Under federal law, it's unlawful to be a user of marijuana, to be in possession of marijuana. It's also unlawful under federal law for a person to be in possession of marijuana or be a user of marijuana and be in possession of a firearm. In particular, the law states that an unlawful user of a controlled substance or a person that's addicted to a controlled substance cannot be in possession of a firearm. It's a felony. In fact, it's a felony that carries a mandatory minimum of 5 years in prison. So, how does that then equate to, and how does that work with state law that says that an adult can be in possession and use marijuana? Does that mean that they all cannot be in possession of a firearm? It starts a lot with the definition of what does it mean to be addicted to marijuana and a user of marijuana. Now, as an adult, Michigan law now is that marijuana is legal. The use and possession of marijuana is legal. And if I were to consume marijuana today, that doesn't necessarily make me an unlawful user tomorrow. So this can have a couple different ways that this could work. For instance, if I want to purchase a firearm from a federally registered dealer, as opposed to like just getting a permit to carry a concealed weapon, which I'll talk about in a second. So under the circumstances where I wish to purchase a firearm from a dealer, a federally registered dealer, that dealer is going to have a form that you have to fill out. This is a federal form. U.S. Department of Justice, Bureau of Alcohol, Tobacco, and Firearms Transaction Record. On this form, it states, and it questions, are you an unlawful user of or addicted to marijuana, any other depressant, stimulant, narcotic drug, or any other controlled substance? And then there's a warning. The use or possession of marijuana remains unlawful under federal law, regardless of whether it has been legalized or decriminalized for medical or recreational purposes in the state of Michigan where you reside. It is legal in the state of Michigan. So the question is then, how does a marijuana user, somebody, just an adult that perhaps may be using marijuana occasionally, how do they answer that question? The question really becomes, to what degree are they addicted to, or are they an unlawful user? I can tell you from the very beginning, if anybody checks yes, they are an unlawful user or they're addicted to marijuana or any other depressant or any other stimulant or narcotic drug, they are not going to be successful in being able to purchase that firearm. It will be denied, because this is an exact reproduction of what is in federal law. It's contained in federal law. Federal law says those that are addicted to a controlled substance, including marijuana, or just an unlawful user, cannot be in possession of a firearm. So this is the language that they're referring to. And I don't want to encourage anybody to break the law and say, or I'd say like falsify a federal form and say, no, I'm not, when in fact that they are. The fact is that there are many people that are frequent, regular users of marijuana, and it can be argued that they shouldn't, and it's unlawful for them to be in possession of a firearm. Unfortunately, that is the law. We will compare that to state law in a second, but when it comes to at least this firearm transaction record, if you put on there that you're an unlawful user, you're not going to get a firearm. Now, if I perhaps have, and as an adult, used marijuana yesterday, that doesn't necessarily mean that I'm a marijuana user today or that I'm addicted to marijuana today. There's many adults that can be infrequent users and I think can legitimately say, no, I am not an unlawful user or addicted to marijuana and be completely within the law and within the right to do so. In addition to that, I could be a medical marijuana patient. And in fact, I am a medical marijuana patient, yet I don't regularly use marijuana. I myself would easily be able to say, no, I am not an unlawful user or addicted to marijuana, even though I'm a medical marijuana patient. First of all, there's going to be nobody checking to see if I'm a medical marijuana patient. Those are protected records that this dealer, the federal government, the state government cannot access those records. Those are records that are protected by health laws, and that nobody can say, hey, wait, you lied on this. But that's not even what it's asking. It's not asking whether you're a medical marijuana patient, whether you have a caregiver, or whether you have a card. It's asking whether you're a user. There can be circumstances, and there's plenty of circumstances where somebody can be a holder of a medical marijuana card and not be a user. So just because somebody has a medical marijuana card doesn't mean that you have to check yes on this document. Next, let's talk about state law, because in state law, that we don't have that federal issue. Under Michigan state law, it doesn't say that an individual that is addicted to or using marijuana is unable to be in possession of a firearm. In fact, that would be unlawful based upon our Recreational Marijuana and Medical Marijuana Act. Those are discriminatory laws that you cannot, it's not going to work like that. But in order to apply for a permit to carry a concealed weapon, the question then becomes, well, what do you answer if there's a question like that? But the answer is that there is not a question like that. And so, like, being a user of marijuana does not preclude somebody from getting a permit to carry a concealed weapon. In other words, that is not a question that is asked. That is not a condition that is necessary in order to be satisfied, unlike in federal law. There is no state law that says that, again, you can't be a user of marijuana and be in possession of a firearm. There's no question on the concealed pistol license. The law that governs the qualifications for getting a concealed pistol license doesn't have anything to do with whether somebody is a medical marijuana patient, medical marijuana caregiver, or whether they are a user, adult use, recreational user of marijuana. So that's simply just not an issue. It's not going to be confronted on this form. Similarly, and if you don't have the permit to carry a concealed weapon, you can still be in possession of a firearm, but you do have to get a license from your local police station. And you don't need that if you have a permit to carry a concealed weapon. So you already have your permit, that is all that's necessary to carry it, your license to carry it. If you don't have your permit to carry a concealed weapon and you still want to have a firearm, be in possession of a firearm perhaps at your home, you do have to go to your local police station and fill out another form, and they ask a bunch of other questions. But you know what? Whether you are a medical marijuana or recreational user is, again, not on that form. So that is not something that has to be disclosed. Again, it's protected health information. It's not something that has to be affirmatively disclosed, and it is not unlawful in the state of Michigan for a medical marijuana patient or a recreational marijuana user to be in possession of a firearm or be in possession of a concealed pistol. It is unlawful to be under the influence of marijuana or any other controlled substance or alcohol and be in possession of a firearm and be in possession of a concealed pistol. So that is a very significant distinction. Being in possession of a firearm while under the influence of marijuana or alcohol or any other controlled substance is a misdemeanor. It is something that people go to jail for potentially. It's something people get in trouble for. And I've done a video on this before where it talks about being in possession of a firearm, let's say in your vehicle after having a couple drinks or after consuming marijuana. That is not what I'm referring to in this video. You can go to my other video to talk about or to listen about a discussion about that. So I think and I hope that clears it up. With respect to state law, there is no prohibition for being in possession of a firearm while being a medical marijuana patient or user or caregiver. There is under state law. It certainly creates a contradictory circumstance. It creates a problem or a situation when somebody applies to get a permit to carry a concealed weapon. They get that permit even though they're a medical marijuana patient or adult use user, and then they go to purchase a firearm, and then they're confronted with this question as to whether they're a user. As I said earlier, I think there's plenty of legitimate reasons that an individual can say that they are not a marijuana user, even if they had used in the past. But there's dangers there too. One particular danger is a situation where a person's in possession of, there's a case that I just read about where somebody was on probation and they were in possession of a firearm in their home, and they were also in possession of paraphernalia, and it was clear and obvious that somebody was regularly using marijuana. And then their probation was violated. They took a drug test. They tested positive for marijuana, and they were prosecuted under federal law for being in possession of a firearm while also being an unlawful user of marijuana. And the court upheld that statute. They upheld the law as it relates to that charge, as it relates to that individual, despite the fact that they were in a state where it was lawful to be in possession of marijuana, where they perhaps were a medical marijuana patient or adult use. So that state law, unfortunately, does not create a defense. So it is something that does require a bit of understanding, and I think that the bottom line is, especially if you're in a situation where it's potentially like you're on probation, or you have a situation where there's federal law enforcement that's going to be interfering with your business, it's best, if you're a regular marijuana user, it's best not to be in possession of a firearm. A lot of people don't want to hear that, but that is the law and that is the case. That being said, I hope that clears it up for everybody. If it doesn't, feel free to reach out to me again if you have other scenarios that you might be interested in discussing with me. It's okay. I am available to provide the advice to the degree to which that I'm able. You can also go to my website, MichiganCriminalAttorney.com, or YouTube, Instagram, Facebook, and get additional information about additional topics. Thank you very much.